I do have skills that make me a nightmare for people like you.
Ms. Thomas.
Thank you, Chair. Just before I formally call Dr. Else as a witness, I would like to take this opportunity to produce two exhibits, and they are from Dr. Maria Hainga-Collins, who would dearly have loved to have been able to present today but was unable to, and I will produce as an exhibit her Masters and PhD for the Commission to have available to consider and peruse for the future. So I produce now the Master's thesis titled Belonging in Whakapapa, the Closed Stranger Adoption of Māori Children into Pākehā Families by Dr. Maria Hainga-Collins as Exhibit 12.
Thank you.
And I will produce...
Does any council wish to raise an objection to that course being adopted? No, thank you.
Thank you. And I will produce the PhD thesis titled Closed Stranger Adoption, Māori and Race Relations in Aotearoa, New Zealand, 1955 to 1985 by Dr. Maria Hainga-Collins as Exhibit 13.
Thank you. Same position? Thank you.
Thank you, Chair. Commissioners and Chair, just before we start, I'd just like to alert everyone that Dr. Ian Else does at times have a hearing difficulty, so we will all need to speak carefully into our microphones for today. Thank you.
Dr. Else, can I begin your evidence by asking you as follows: do you solemnly, sincerely and truly declare and affirm that the evidence you will give before this Commission will be the truth, the whole truth, and nothing but the truth? Thank you.
Thank you. Good morning. Dr. Else, just to confirm, do you have in that folder before you the signed brief of evidence with today's date, which is your brief of evidence?
Yes.
Thank you.
Yours for some reason.
Do you also have in front of you your book titled A Question of Adoption, Closed Stranger Adoption in New Zealand, 1944 to 1974?
I do.
Thank you. I would ask for you now to present that book to the Commissioners.
Thank you.
Can you please introduce yourself with your name and your area of expertise to the Commissioners?
My name is Dr. Anne Else, and I have a number of areas of research interest, but adoption has always been a major part of that, and that is partly because I am myself adopted. I was adopted in 1945, and so I wrote the book that I needed to have for myself, and knowing that, or thinking that it would be helpful to other people in my position. But since that book, of course, I have gone on and written a number of other articles and chapters and books and so on, also dealing with adoption in New Zealand.
Thank you. If we could start with your brief of evidence looking initially at the situation in New Zealand before 1945 in terms of adoption. If you could tell us about that, please.
Well, it was not common to adopt children before 1945, and in particular adoptions of babies were very uncommon. Adoption was seen initially as something that you acquired a child of useful years who would help you on a farm or something like that. And secrecy wasn't initially involved at all. We were the first country in the British Empire to introduce legal adoption. But the other issue was that the most usual solution to prenuptial pregnancy from at least the 1920s on was hasty marriage, and that ensured that the child was born legitimate. It should be noted, however, that there were different procedures for recording Maori births, and so it's not possible to talk about Maori legitimacy in the same field.
Dr. Else, I'll just remind you that we're typing everything here, so we just need to speak more slowly.
Okay. So the other factor was that if you did not marry, and of course there were many women who became pregnant and could not do that, keeping an illegitimate child was seen as a fitting punishment for sin for the mother and for the child. In fact, anybody who found themselves unable to carry the dual roles of parenting and financial support, including, of course, a number of single mothers, were liable to see their children end up in institutions. And they were charged for keeping their children there because the thinking was, okay, we've put your child in an institution, now that leaves you the time to earn the money to support it.
So they were charged by the state?
Yes. So, for example, in 1939, the Society for the Protection of Women and Children protested about police prosecuting unmarried mothers because they'd fallen behind in the maintenance payments for their children. So it was a completely different attitude.
Can you tell us how things changed in the post-1945 era?
Yes, well, in the first place there was World War II, which meant that marriages were delayed, men came home from war with their fertility impaired, so the number of people unable to have children actually increased a great deal. Plus the number of children born ex-nuptially, for example, to women whose husbands were away on service, also increased. And the institution of adoption was still not under complete control of the state. The adoptions were usually privately arranged, but we did have the law to take care of them, and so the numbers began to rise from that time onwards. However, by 1955, the increase in adoptions had prompted the state to look at changing the law with the object of having the state have much more complete control over adoptions and regulating the way in which they took place. And so that was done in 1955, and that act is still in force today.
And in your brief of evidence, looking at paras 6 and 7, there's also a table on that page.
Yes.
If I could ask for that table to be put up on the slide now. Could you take us through that table with some points that you'd like to highlight?
Well, you can see that in 1943, for example, there were only 577 adoptions in total, and at that period there were a very low percentage of live births. But by 1960 they were still only around 3% of annual live births. But you can see from this table that adoption is not a simple matter. There were total adoptions, and them as a percent of live births, and then there were adoptions known to the Child Welfare Division. So some adoptions took place at that early period before child welfare had any involvement at all. Then after that, the figures changed so that by 1979, every single adoption is known to the Child Welfare Division, well, it was social welfare by then, because they were in charge of them. Now, the adoptions involving ex-nuptial births were only a portion. There were also step-parent adoptions and inter-family adoptions and things like that. But they were the substantial, they were still the most substantial category of adoptions in this period. And adoptions by strangers almost match adoptions involving ex-nuptial births, but not quite, because there were still inter-family adoptions, mothers, for example, adopting their daughter's child and so on. So adoptions of children under 1 year old is an indication of the normalisation of very early adoptions, which took place through this period. But even then, from the early 1970s, the figures begin to fall away, so that by 1979 we're down to 2,200 a year, and only 845 of those are adoptions by strangers. So the heyday of closed stranger adoption, which means adoptions by strangers to the family, which was closed in the sense that the birth parent did not know who the adoptive parents were, actually occupy a relatively short but very influential period of time in our history.
And just to highlight, what years were the times where adoptions by strangers were the greatest?
Well, the greatest number of adoptions was 1971, but the greatest number of adoptions by strangers was in 1970, when 2,286 took place. And then they begin to decline after that. In percentage terms, it was actually 1962, because it was almost 78% of total adoptions. The last year in which adoptions by strangers made up more than half was in 1974. So by the mid-1970s, that form of adoption was rapidly declining.
You've told us that things had changed in the post-war era in New Zealand. Can you tell us, why was adoption the answer to the changes?
Well, the state had always been concerned about single women having babies. This was thought to indicate immorality and sinfulness and so on. The sinfulness fell away, the immorality to some extent fell away, and people began to see it as a mistake, that this was an otherwise good person who had simply made a mistake. And given the rise in the numbers of people wanting to adopt a child because they couldn't have one, this was seen as the perfect solution, not least because it came at virtually no cost to the state. And the 50s in particular, and on to the 60s, there was a very strong normalisation. The normal family was a mother who probably stayed home, a father who went out to work, and children. And so the transfer of an out-of-place illegitimate baby born to a single mother into a family of a married couple to become their child was seen as both kind and sensible. It was this perfect solution to this perennial problem of what to do with these children.
And also, what were the thoughts around what was for the baby itself?
It was seen that this gave the baby a legitimacy, which was extremely important. It gave it a normal pair of parents. It gave it security, apparently, although the stories legion of one parent dying soon after the birth wasn't always the case. But it placed the baby on an equal footing with other children, so it could grow up with a completely lifelong, secure, new identity. And for the birth mother, it enabled her to start again as if she had never had the baby, and marry and have other children of her own. That was the thinking.
So that was the thinking of the time?
Yes.
Did these unmarried mothers have other options at that time?
Surprisingly, when you look at the figures, a percentage always did manage to keep their children. But to do that, a number of things had to exist. They had to usually have family help. They had to not be cast out of the family, certainly. They had to have some means of earning a living, either because somebody else could take care of the baby, or they could take up a position, say, as a housekeeper or something where they could manage. Some women simply pretended that they were married and carried on and said their husbands were away or something. So people always did manage to keep their children, but many did not. The people who did not manage tended to be better educated, from middle-class families, and to have been sent away. Those were the groups which were most likely to adopt out their child. And it was extremely difficult not to be caught up in that system, given the pressure. The main pressure was that you were told, you must not be unselfish. We understood you wanted to keep the baby yourself, but that was selfish. The right thing to do for the child was to give it up to a proper family.
And that pressure that was, or those words that were spoken to these unmarried women, who would be telling them that?
The people in charge of the homes where they went certainly were doing that. The social workers were doing that, because once a single pregnant woman got into a home, the social workers had to be informed of all exnuptial pregnancies or births. And in the case, once you were in a home, they would get to you early, as it were. On the other hand, if you didn't do that, or you were just staying with friends or a clergyman or something, at some point it would probably come up. So there were numerous sources of pressure. It was not supposed to be pressure, it was supposed to be information and making sure the best thing happened for the baby, but that was how it was done.
Turning now to the 1955 Adoption Act. Can you tell us what was the purpose of that act being introduced in 1955?
It was definitely part of the expansion of state control over social life, and it's true that there were some cases of abuse and malpractice in the private homes who were mainly in charge of unmarried mothers, and there were some difficult cases where adoptions went wrong and so on. And so the state had a vested interest in controlling adoptions. It was done supposedly for the good of all concerned, and this is why the Adoption Act was such a major piece of legislation. And the discussions in the House, which are covered in my book about the Act, show exactly how and why it took the shape that it did. And of course, you must remember that in those discussions at that time, it was virtually entirely Pākehā men deciding on what should be in the Act and shaping it.
And as a result of that Act, there was much more comprehensive state involvement in the process of adoption?
Yes, well, it mandated. The social workers were already involved in the hearing when the couple came to court to get the interim adoption order for the baby. They came with the baby. Social workers would have already done a report on the applicants saying they were suitable to adopt, but often they would do that very late in the piece. However, after the Act, they became increasingly responsible for matching the applicants and the children. And that was the major shift that occurred, so that the private homes, doctors, etc., who had done that before, as in my case, it was an arrangement between the doctor and the family, that was handed over to the state, and that was partly because of the growth in adoptions and in exnuptial pregnancies. It became beyond what private institutions could manage. So the state became the comprehensive arranger of adoptions over this period.
And at paragraph 12 of your brief of evidence, you've talked there about the adoption by unrelated strangers ensuring a complete break. Can you please talk to us some more about that term and what this means?
this was the theory which governed thinking about the adoption of ex-nuptial children at this time. And it was seen as both essential and beneficial for those involved. And as I said before, it meant that the adoptive couple gained a child in complete security. Nobody could upset that. The child gained this new family, and the birth mother gained the ability to carry on with their life as if nothing had happened. But essential to all of that was seen the principle that the two should not have anything to do with each other. The birth mother in particular was never to know where the child had gone, because there seemed to be a kind of buried recognition that she might at some point want to know what had become of it, and she was not permitted to do that. There is nothing in the Act which forbids her to look for her child, but everything else to do with adoption, starting with the covering up of the adopters' names on the paper she signed, and later on the replacement of that by a form which did not show their names at all. Everything was designed to ensure that she knew as little as possible about them and would not be able to find the child afterwards. She was given very little information, for example, very general information about who was adopting her child. She did, however, have to consent to a particular couple, not to adoption in general. That was the legal transaction, consenting to that particular couple. It was thought much better for the child, of course, that it should not have the confusion of more than one set of parents. Adoptive parents were taught to tell the child that it was adopted and that they had chosen it as their child, but that did not extend to the child growing up and wondering why it was adopted in the first place, of course. So the whole thinking was that this was an end to the relationship, and legally the Adoption Act completely severs all legal relationships between the adopted person and its entire birth family. They are replaced by the relationships of the adoptive family.
You've mentioned consent. Can you take us through how it would work in terms of a mother placing her baby for adoption, the process of that?
Well, at some point in her pregnancy, the mother would agree that she wanted to have the child adopted, and from that point on, there wasn't much that could happen until the baby was born in terms of placing it, but social welfare kept a file of applicants for adoption whom they had inspected and decided were suitable. So once the child was born, they would set about matching that baby, and then the mother would consent. Now, in our law, she consents 10 days after the birth, which had, of course, the effect that it gave her no time whatsoever to see if she could make any alternative arrangements and keep the child. It was one of the shortest periods in adoption legislation around the world, and it is still the period in law that she can consent in. Part of wanting that short time was that it enabled the adopters to take the child home from hospital at about the same time as if it had been born to them. At that stage, they did not have an interim order because she hadn't yet consented, but there was an arrangement in the law that the social workers could place the child with them on a temporary basis, and then they would get the order once she had consented to the adoption. She did not, of course, appear in court. They were the only people who did.
So the adoptive parents were the only people who appeared in court?
And the social worker, that was all.
What was the father's involvement, if any, in this process?
The birth father's consent was not required. At least there were particular circumstances which the court would judge that it would be pertinent. In other words, if he had supported the child, if his name was on the birth certificate, Mostly that was not the case. If there was some reason, they would seek his consent, but generally, in law, his consent was not required at all. The key legal difference between legitimate and illegitimate children is that illegitimate children have no legal father. And in law, they are filius nullius, the child of no one. So the father had no legal standing. The mother, on the other hand, was the natural mother, and she became the child's guardian by default. Because for married couples at this period, the father was the legal guardian and not the mother.
So that rule around guardianship, how is this significant for cases where the birth mother was Pākehā and the father was Māori?
The majority of Māori babies who came into the formal Pākehā adoption system were the children of Pākehā mothers and Māori fathers. In many cases of adoption, ex-nuptial pregnancy, the girl's parents would not want her to have anything to do with the father, but that was doubly so where the father was Māori and she was Pākehā. So the young woman was liable to know very little about the father. She would know his name, but she didn't know, for example, what iwi he was or anything like that. As I say, the fathers were generally kept out of the process, but Māori fathers were particularly kept out of the process because of the racist assumptions of everybody concerned, really.
And how did that impact, in particular, in relation to Maori families where grandparents potentially would have liked to have adopted the baby or had the baby in their care?
There were also Maori social workers, and when it was a Maori mother, they would usually deal with her and urge her to inform the family. So most children born to Maori mothers would in fact be taken into the family in some way. Not all, but many were. Where the mother was Pākehā and the father was Maori, in some cases a Maori social worker would find out, and in some cases the parents would find out themselves, and frequently the Maori grandparents were extremely keen to have the baby and not to have it alienated from them. But where the Pākehā social workers were concerned, this was very strongly discouraged. There is no doubt that it was seen as a step up for the child to be adopted into a Pākehā family, and the way the adoption system worked, even if the Maori grandparents managed to go to court or make some claim, they were grandparents, they were seen as too old, too poor, and less good for the baby because they were Maori, after all. So once a young woman who was pregnant was entirely within the Pākehā system, it was very, very difficult for Maori grandparents to have a say about the baby, let alone to actually have it, be allowed to have it.
You've talked to us about the timing around the consent. The time to sign the consent was 10 days. Can you tell us about the timing of the adoption process up until the final order? The law makes it quite clear who had the options. It was the adoptive parents who had choice, not the birth mother. She signed the consent and that was that, although the law purports to offer withdrawal, in practice it doesn't. And very few women succeeded in overturning a consent. On the other hand, the adoptive parents first managed to get the baby before any order was in place. Then they would get an interim order, and they did not have to apply for a final order for up to 12 months. Many applied sooner, but they had that long, which actually gave them time to change their minds. And social workers did tell them
that they had time to change their minds. If they decided that this baby was not right for them or any other reason, they could do that, and a number did do that. So the choice was in the hands of the adoptive parents and not the birth mother at all.
If the adoptive parents did change their minds in that period, was the baby given back to the birth mother?
Not usually. In law, although very few birth mothers knew this, she remained the child's legal guardian until the final order went through. But very few knew that. If an adoption broke down at any stage before the final order, occasionally the child was adopted by somebody else, and the birth mother would in that case have to give a new consent to a new set of parents. But that would be pretty much the only case. If the adoption broke down and, as we'll talk about later, the child entered state care for some reason, it was very rare for the birth mother to be consulted. Birth mothers would not usually know that there had been a problem with the adoption unless a new consent was required.
Can you talk to us a little bit about the birth certificate of an adopted baby? What did that show and what did it not show?
This is another thing that happened in 1955. The baby had its original birth certificate, and the mother actually had the right to name the baby and to sign that original certificate. In my own case, it didn't always happen. In my own case, I was not named. My mother was never legally asked to do that, though she should have been. When the adopters adopted the baby, they would almost always, well, it would get a new surname, of course, and mostly it would get new Christian names as well, conferred by them. And a new birth certificate would then be issued, which made it appear that the baby had been born to the adopters, even if the baby was like, a few months old by then. So the new birth certificate was the only one officially available to anybody, and only under extremely narrow and unusual circumstances would anyone have a right to see the original birth certificate. It was, to all intents and purposes, locked away. It wasn't destroyed, but it was locked away. So that was because in law, as I said before, the adoptive family became the child's only legal relatives.
What was recorded by social workers, especially with regard to mixed race children at that time?
Social workers didn't record a great deal at all about the babies, and what they did record was not always shared with adopters. They were circumspect about how much they told them. With mixed race children, sometimes all that was known was that they were mixed race. They would guess. And parents, the wrong information could be entered. Children could be entered as Maori when they were Pacific, or Greek when they were Maori, or, that it's not entirely reliable. They didn't always know, partly because the mother herself, the only person with information, didn't always know what race the father had been. So in terms of what was significant to Maori about the child's connections, its whakapapa, Surangawawa, its entire heritage, that appeared to be completely neglected if it was Pākehā social workers. I have never seen information about that, and it seemed that they were completely unaware of the significance of that for Māori. They would have had to go back to the father to find it out anyway in those cases, and they didn't do that. And so their main interest was in getting the baby adopted, and they knew that any degree of mixed race of any kind, but in some ways particularly Māori, was automatically going to make that child more difficult to find adoptive applicants for. Their main concern, therefore, after the child was born, was what it looked like. the files are full of comments on how dark or not children were. For example, would possibly do for such and such a couple, if not too dark.
And if we turn now in your brief of evidence to the topic too many babies, which is from paragraph 18, can you tell us first what happened in terms of demographics in New Zealand in the 1960s?
Right. There was not a sudden shortage of adoptive parents. If anything, that increased. The percentage of children adopted went up to between 5 and 6% of annual births. It was high. So people were still adopting children, but the demographics meant that with the baby boom there was a large increase in the population of the age which was probably going to get pregnant, either married or unmarried. A lot of women were going to get pregnant. And that was increased partly by the aftermath of the Masengard report, which brought in, which saw, believed it was all a question of fighting immorality, and passed a law that children under 16 were not permitted to have access to contraceptives or information about contraceptives. So they were completely cut off from birth control knowledge, which naturally increased the number of ex-nuptial pregnancies. And so for the first time, the supply of babies, as it were, for adoption, and we're talking younger, the ages of the mothers got younger on the whole, so that meant they were even less able to look after a baby on their own. That increased exponentially, and that was what caused the problem. Both private homes and hospitals had a flood of babies who were supposed to be available for adoption, but not enough people to take them.
And as a result of this, did market forces have a part to play?
Yes, market forces were in adoption from the beginning. The people with the most status in the Pākehā world had their pick of the children. And as I said, mixed race children were always difficult to place. But in this period, market forces really took over. Obviously, money wasn't involved, but both adopters and children were ranked. Not formally, but informally ranked. So the best children went to the best adopters, who could literally pick and choose. They could be offered several different children. Whereas you go down to the other end, and the less desirable the child was, this was not only race, but also things like any disability, red hair, simply being male. Boy children were less popular, or any difficult family background. All of those things combined to push certain children down to the bottom of the hierarchy, and it was inevitable that some of those children would not then be adopted.
And were those less desirable children referred to as hard to place?
Yes.
Right. Have you got a quote in your book at page 81, I think, of your book in relation to a comment made by a social worker on this sort of topic?
Yes.
The rankings.
One social worker wrote on the file, this is about, as I was saying, the adopters were ranked, and this was about ranking the adopters, and she said that they were a very ordinary couple, but okay for a C baby. In other words, if the couple was not particularly highly ranked, then they would still get a baby. Everyone would virtually get a baby, but they would get one of the less well-ranked babies.
In terms of the choice of who would get which baby, who was in charge of that decision?
The social workers were in charge of that decision, and they were worked off their feet, so they were making these decisions sometimes quite quickly. There was one case in my book where, because New Zealand's a spread out rural area, they actually took to flying babies to adopters sight unseen. And in one case, a couple got a mixed-race child to adopt, and they discovered that that child had twice previously been flown to adopters sight unseen, and both of them had sent it back because it was too dark.
If we could turn now to your brief in terms of a snapshot of what happened to ex-nuptial children. I think you've talked about a report that was published in 1976 by the Department of Social Welfare, which gave a snapshot of what happened to ex-nuptial children who were born in 1970.
That's correct. Although social workers had a duty to visit all ex-nuptial children and find out what circumstances they were living in, they didn't always get round to all of them. So it was decided that there would be an in-depth study done. At this point, social welfare had recently embarked on doing more research, and they decided that they would make a point of visiting approximately half of all the ex-nuptial children born in 1970. They almost achieved that, but not quite. And they recorded the situations of the mothers and children. They interviewed the mothers, and so that year there was a far better picture of what was happening to the children.
Did that survey adequately cover the experience of Māori children?
No, it was noted from the beginning. You have to remember that the statistics for illegitimacy among Māori were much higher than for Pākehā, but that was partly because a much higher number of Māori couples were in de facto relationships. So many of the children who on paper were classified as ex-nuptial were actually born into perfectly stable family unions. Plus the fact that Māori single women who became pregnant were much more likely to be helped and supported by their families. So they were in a much better situation. So those higher legitimacy figures they were an artefact in some ways. However, it was true that they did not reach a number of, the percentage of Māori mothers of ex-nuptial children born that year, there was a lower percentage of them were actually reached by the social workers, probably because they had no need of the social workers, so they had not actually come into contact with them at all. So however, there were some Māori mothers and children included in that survey.
And if I could now ask for the next slide to be placed up there, and if I could ask you, Dr. Else, to go take us through some of that.
This is the only close-up snapshot we have of a large population of ex-nuptial mothers and children, and it lists the placement situation at the end of the inquiry, which could be a bit after 1970. It took them time to find some mothers. So at the end of the inquiry, the two most common situations were placed for adoption, not with relatives, in other words, stranger adoptions, and with the mother not cohabiting. And interestingly, by 1970, almost as many children, well, actually slightly more children, were with the mother than with strangers, but some were also adopted by relatives. So the numbers were roughly equal. Then some of them, the mother had married the child's father after the birth. Some, quite a substantial proportion, were living with the father. Some mothers, a very small number, were living with another man. And in 100 cases, the children were with other relatives. That was a cluster of Māori children mainly, who were with other relatives. Right at the bottom, you've got the small group who were effectively in state care, in foster homes, in a hospital or an institution, or committed to the care of the superintendent of child welfare. It's a small group, but that is the only clear evidence we have of that group of children. Because of the vagaries of adoption, some children would end up in state care rather than adopted.
And that was when they were aged between 1 and 24 months?
Yes, pretty much so.
Just in terms of this topic of state care and how ex-nuptial children could enter state care, from paragraph 26 onwards of your brief, you talk about 4 different pathways
Yes.
into state care. Could you talk to us about those?
Yep. We don't know how exactly. I've worked this out for this inquiry. I looked at it again and worked out the possible pathways that this could happen. So some of them had nothing to do with adoption and some of them did. So the death of the mother. Now this is interesting. 15% of births were to single mothers, but a third of all the deaths of mothers in giving birth were single mothers. It was a far higher percentage than it should have been. And we can only assume that in many cases it was neglect or it just was quite striking. So if that happened and there was no family to take over, the child would enter state care. Occasionally we had this phenomenon of the so-called abandoned children, where the mother would leave the hospital. Now, in most cases this was not abandonment. The mother had already agreed to adoption but not signed a consent. She was probably desperate to get away because she was in the hospital with her child, whom she had quite possibly not been permitted to have anything to do with. She might have seen it once, she might have held it once, that would be it. Otherwise the child was kept away from her. And that was a ghastly situation. So the mothers were not so much abandoning their children as simply under intolerable stress, and they took off. And in some cases, if they couldn't find them and she didn't consent formally to adoption, the child would enter state care for that reason. But the state used the word abandoned. Sometimes the child was placed in state care, and this could be the case, I would imagine, thinking of Robert this morning, of disabled children in some cases, which would have been extremely difficult for a single mother to care for. But there would have been reasons, we don't know what those were, but there could have been reasons why that was the case, and she consented to it. On the other hand, they could be taken into care by child welfare, and she might or might not consent to that, just as they can be today. If child welfare found that they did not approve of the environment that they found the child in for any reason, then the child could be taken into care. And then you could enter state care, as I explained before, as a result of adoption failure at any stage of the adoption process, including after the final order. If the adoption broke down at that point, the child was unlikely to be readopted. It would be too old. Sometimes it was, but it could also enter state care at that point.
Just in terms of adoption failure per se, how common was that?
We don't know, because child welfare did not keep any statistics or records overall of the instances of adoption failure. Concern mounted about it happening. The social workers would know that it had happened usually, and they became quite concerned about it, and that resulted in a small study of 44 such cases in the 60s, and then a private research project by Diane Zwimpfer looked at 80 cases of adoption breakdown, and that was very informative. Now, in some cases, social workers had tried to prevent the courts approving the placement or the interim order or even the final order, because they had seen, in their opinion, factors which made it unwise for the adoption to proceed. But they were very, very rarely heeded. Judges preferred their own on-the-spot opinion of the couple with the child. The social workers recommended against an order only if they had really concrete grounds or very strong feelings. But even so, they were mainly disregarded, and the adoption would proceed, and those would be, of course, at high risk of breaking down. Overall, the number that broke down was probably not very high, but of course it was pretty disastrous for the child.
And as you said earlier, if a breakdown did happen, the child was not returned to the birth mother.
No, it was not returned to the birth mother. It's after the final order, of course, she was no longer its mother. But even before that, it would probably not be returned to the birth mother, no. Unless she somehow found out and got it back, which occasionally happened, but very rarely.
Now, you've mentioned this briefly already in your evidence, but just turning to paragraph 31 of your brief, you've talked there about the 1950s and in the 60s, the degree of Māoriness.
Yes. It was interesting. I didn't know this until I did this research for this. The only statistic officially recorded regarding the race of all children in New Zealand was degree of Māoriness, and a quarter or less was considered to be European. But because the social workers created their own records and because mixed race they knew was such a salient factor likely to make children difficult to adopt, they did keep records on it, but it was all about, it was an entirely Pākehā perspective and circled around what was likely to be acceptable or less acceptable to prospective adopters. They just did not understand anything about the significance of Māori heritage at all. And the difficulties, are well recorded in the archives right back into the 50s. This was well before that so-called surplus of babies developed. For example, in 1956, one child welfare district officer explained that there was a shortage of babies of the right kind, but a glut of the wrong kind, and wrote, "Our waiting list of those wanting to adopt is nearly 500 strong, and we have only about 80 babies a year to place, so at that period it was hard to get a child. This includes all the part Māori ones, of which sort we have had and can expect to have far too many." So many mothers of mixed race children, including of Māori children, knew that adoption would be more difficult to achieve for their child. And they were explicitly told that in many cases. But as Maria Hanger-Collins' research has shown, it was those with Pākehā mothers of Māori children who were more likely to be in that position. Sometimes Māori mothers were also in that position, but it was less common. So that was awful. They were told that or believed they had to have the child adopted, but knew it would be difficult to find parents for it.
And we've heard earlier in this inquiry from Alison Green, and part of her evidence was that she was referred to as having a touch of Spanish in her. Is that something that you've seen in your research?
Yes. It was, in some cases, the social workers did not actually tell the adopters that the child was part Māori. They said it had a touch of Spanish. In other cases, and more commonly, they would tell the adopters to say it had a touch of Spanish and not that it was Māori, which they knew that it was. And this is just one of the strongest indications you could have of the attitudes towards Māori among Pākehā at that period, that it was something to be concealed. Sometimes they could find a Māori couple to adopt an unrelated child. I gather that at Wairau, for example, there were a number of Māori soldiers and their wives who adopted unrelated Māori children, but this was not very common. And in any case, they did believe that a Pākehā family were better for the Māori child, if they could be found.
If we turn now to the post-1972 environment, what was changing in New Zealand at that point?
Well, it was becoming evident that the treatment of single mothers was extremely unjust. And it also applied to divorced mothers too. Women parenting alone, mainly women of course, though in some cases men as well, parenting alone were in an extremely difficult position, and there was growing pressure on the government to make some provision for them. Widows were already provided for because they were the deserving single parents, but the others at that point were not. And so a lot of pressure for that came from social workers who saw how difficult it was for women to either give up their children or to keep them. So they too were pressing, and they knew the mothers wanted to keep them, and they also knew that they needed to keep them. There weren't enough adopted parents, so they were pressing very hard for some sort of official allowance for single mothers. And in 1973, the domestic purposes benefit was introduced. However, it was already clear from the statistics that more and more mothers, either in de facto relationships or on their own, were keeping their children, that the DPB itself was not responsible for that trend. And so it was, of course, however, extremely welcome, except that quite a large number of single mothers still didn't know about it. It was still possible not to know about it. And when it once again began to become apparent in the 70s that there were more couples wanting to adopt than there were babies available, this was blamed on the DPB, which was said to encourage immorality and single pregnancy, and at the same time to be denying adoptive couples the child that they should have had a right to have. But that was completely untrue.
Just looking at that trend that you've mentioned in the time prior to 1973 with the introduction of the DPB, if I could ask for the third slide to be put up on the screen, please.
Now this graph shows you very clearly the trends in what happened to the children of technically illegitimate children. And you can see that the top line is adopted by strangers, and that started was around 40%. If you remember, I said that 1962, the year of the start, was the highest percentage of adoptions of babies born that year. And then it starts to trend down from about 1967. And this is the percentage of all the children. So you've got rising numbers of children, but the percentage of them being adopted by strangers goes down. And by 1972, there are more babies remaining with mothers on their own, not cohabiting, than there are being placed with strangers. It crosses just at that point. And that was, of course, before the DPB. And then the cohabiting mothers actually goes down as a percentage, but it is of an increasing number of children. And so then it rises again, and of course cohabiting gradually becomes so common that it's touching on half by the time you get to our time, so that there's really no point in counting who's married, who's not anymore. And then the other situations at the bottom, there's that little line at the bottom, those are the ones who got married. And then that other situations, that basically meant the ones that the social welfare didn't know what had happened to them. And that's why in 1970 that drops away to nothing, because that year they did know what had happened to them.
Because that's the year they'd done the survey.
That's right, yes. But it's very clear what those trends are. Women do not give up their children unless they've got no other option, on the whole.
Just moving now to your concluding remarks, but before I get to your comments about the adoption system in New Zealand and looking towards the future, can I just ask you, in your opinion, what was the act of adoption itself, in your opinion, an abuse?
It's a very difficult question to answer. The best I can do is to say that because the focus here too is on the children, I'm setting aside for the moment the effect on the family, as in the birth family and so on. But focusing solely on the children, adoption in itself, in its most basic form, is simply a legal process for transferring legal parenthood. But the nature of our Adoption Act makes it much more than that. In the post-war era, it became a process for cutting off the entire family of the ex-nuptial child and replacing it with the adoptive family. And this, I believe, can be seen as a state-backed form of deprivation, because it did deprive, and was intended to, and until the Adult Information Act did, deprive the adopted person of any knowledge of or experience with their entire birth families. This could happen because the birth connections of an ex-nuptial child were seen as of no value. And that really seemed to hold good no matter what status those connections had. Indeed, the higher the status of the birth family, the more important they seemed to think it was to get rid of the ex-nuptial child. So there was no value attached to a child being connected with its birth family if it had had the misfortune to be born ex-nuptial. And so that position was held by, I would say, probably the majority of Pākehā families, certainly, and particularly middle-class Pākehā families. The women most likely to give up their children for adoption were a bit better educated, a little bit better off families, and placed in an institution, cut off from other help. So this kind of deprivation has consequences, and Dr. Alison Green yesterday very eloquently spoke of the consequences of the loss of those connections. Now they particularly, they have wider and different consequences for people of Maori heritage, given the way in which your birth connections and history are such a crucial part of who you are in the Maori world. But they have consequences for all adopted children, actually, and those were only partially mitigated by the Adult Adoption Information Act, which often proved of very little use to Maori, because if their father was Maori and he's not recorded, they had great difficulty finding out anything further. It's the state codified that and sort of mandated it, really, because a large number of adoptive parents have written various submissions on the Adult Adoption Mandate, saying that they would have really liked to know who the birth mother was and share their child's upbringing with her, but there was no room for those sentiments in the Act. So that once children are cut off from their birth families, I believe that they are put at risk. Adoption was at least probably the most secure form of transfer, but it was also the most complete form of cutting off. So it was at the very least a deprivation, and it could put them at risk later on. And the more at risk they were in our society to start with, simply by being Maori, disabled, whatever, the more likely getting into the adoption system was to put them at risk, either at risk of adoption breakdown, of not being adopted, of entering state care, with all the consequences that followed that. So in that respect, it was simply based on completely wrong and misguided premises. And it still is. That Act is the oldest statute in regular use. And while practice has been reformed, the fact is that is still the law.
Just on that note, Dr. Else, what, if anything, would you like to tell the Commissioners in terms of that Act in the future? of that 1955 Act?
The Act has been severely criticised both nationally and internationally. It does not comply in any respect with the Conventions on the Rights of the Child. It does not comply with the Human Rights Act or the Bill of Rights Act. It does not comply with informed consent. Even the consent process is in no way fully informed. And it does not comply with the child's right to understand its identity and be with family. It calls for its complete reform have been going on for at least 20 years longer. And at no point has any government heeded that to the point of setting up a comprehensive reform process. So that is extremely long overdue, and it is of particular importance to Māori. Aotearoa too had a great deal to say about the inequities of the Adoption Act for Māori. My own book is a whole chapter on that, and it is crucially important that we see to the reform of that Act as part of our complete system of child welfare, which puts the interests, makes the well-being and best interests of the child paramount. None of the adoption acts do that.
Thank you. Thank you for your evidence today. I'll hand over to the Chair.
Thank you, Ms Thomas. Council, are there any of you who wish to address questions to Dr. Ells? So if you go across to the microphone. Mr. Stone.
Could you just raise your mic a little bit, please? Thank you.
Tēnā koe. Thank you for your evidence. In your evidence, you spoke about grandparents wanting to adopt and how the Pākehā social workers at the time said no.
And so did the courts, if it ever got that far.
This, of course, would have led to a loss of whakapapa and identity and all that it entails. So the whakapapa of the child wasn't really the focus of the whole process, was it?
No, it was completely ignored in the Pākehā system. It was not ignored by Māori social workers, but it was by Pākehā ones and everyone else in the system.
You used the word alienation, and ordinarily we use the word alienation in respect of Māori and their land being alienated. I was pleased that you used that word in respect of the Māori children being alienated from their culture, their whakapapa, their hapu, their whānau, their iwi, their language, all that sort of stuff. And you mentioned as well, you used the word market forces, and you said the best children went to the best adopters. Now I'm assuming that the best children, they weren't the Māori children, were they?
No, the best children were the little white blonde Pākehā girls.
So I would have been sitting on the shelf for a while then if I'd been there. And the best adopters, they came from money?
Yes, they had more money and education and standing in the community.
And were they more likely to be Pākehā?
They were almost invariably Pākehā because very few Māori families actually entered that system to adopt unrelated children. That was not common at all. It did sometimes happen that Pākehā families, especially as we got on and towards the 1970s, some Pākehā families with strong social consciences believed that adoption was helping a child, and they would deliberately seek to adopt mixed-race children, thinking that they were doing a good thing by doing that. So that did also happen.
To what degree, or would you put it another way, would you agree with this comment that the whole process was controlled by Pākehā for Pākehā?
Yes, the law was entirely Pākehā constructed. The only mitigating factor was the Māori social workers, who did sometimes manage to work in a Māori way with mothers of Māori children and fathers of Māori children. But apart from that, the whole process was thoroughly Pākehā.
And there must be Māori people today walking around who have no idea who they are.
Exactly, and Maria's MA and PhD thesis is focused very, very informatively. She interviewed people in that position, and I really commend her thesis to you. She takes much further than I can these aspects that we're talking about now.
Dr. House, thank you.
Thank you.
Thank you, sir.
Thank you, Mr. Stone. Commissioner colleagues, any questions? Starting with you, Dr. Oh, I beg your pardon. The commissioners will wait. Ms. Dyer-Kidd.
Thank you, sir. Dr. Else, my name is Fiona Guy-Kidd, and I'm appearing for the General Synod of the Anglican Church of Aotearoa, New Zealand and Polynesia. I'd just like to ask a question which relates to the impact on the mothers at the time of the adoption. You've spoken about the impact for the children. So looking at it from the mother's perspective, and it seems that the peak times were 1970 in sheer numbers and 1972 in percentage.
The 60s.
The 60s.
Well, no, sorry. If you're talking about adoptions, children available for adoption, it was the 60s. But yes, the number of mothers certainly grew and grew right through the 70s, yes.
So in the 70s, what was the impact for the mothers, both then and subsequently, of adoption, if you're able to speak to that?
Well, I think the impact of adoption on mothers remains throughout the entire period.
Yes.
To have your child permanently removed and, above all, never to know what became of it, whether it is happy, whether it is well. Many mothers desperately wanted to know that their child was all right, that they'd done the right thing by giving it up, and that it had attained the happy life they'd been promised it would have. But of course it was most of them went through their whole lives not knowing that, until we got the Adult Information Act, and then people were able to contact their birth mothers. It was an extremely severe impact. I mean, it's such a double standard. We were having, on the one hand, motherhood held up as women's supreme duty, which is why married women who couldn't have children felt so compelled, and I think still do in many ways, to have a child, and that was the way you did it then. You adopted one. And on the other hand, if you had the misfortune to become pregnant and be unable to marry out of wedlock, suddenly the mother was the worst thing for the child, and it was her duty to give it up. But given that we have a great deal of evidence that mothers do care deeply about their children, it was evident that this was an extraordinarily difficult period in their lives. And we have ample evidence of that, which came to light through the campaign, which took 7 years to get the Adult Adoption Information Act through Parliament, that birth mothers spoke out en masse pretty much for the first time about what it had been like for them to lose their child in that way.
Thank you.
Thank you. Now, colleagues, Dr. Edeweti first.
Tēnā koe, Chair. Tēnā koe, Dr. Rouse. Thank you for your evidence. I have a question about whāngai, about Māori customary adoptions. And because this practice has been going on for many, many generations, but the Adoption Act doesn't allow for it or recognise it. about the risks that that might cause for children and whāngai parents for that child not having a formal legal status? Is there, for example, a risk that that child could be taken out of a whāngai placement?
I haven't seen any evidence of children being more likely to be taken out of a placement if it was whāngai. I'm not sure that that would be the case. I think the main consequences for whāngai children and their parents, or their caregivers, were that they were, because it was not a legally recognised arrangement, and that need not be adoption. For example, the grandparents could have legal guardianship. But if they didn't, if there was no legal arrangement in place, it cut them off from everything such as the family benefit and any financial help of that kind. And as we know, the number of grandparents caring for children is actually rapidly rising, and they're still in a similar situation. The rules around when they can get help and when they can't are very unrealistic. So that, I think, was probably the major consequence. I don't think social workers were not rushing in to take whāngai children away. No. In fact, in many cases, I think probably the whāngai arrangement had put the child in a better situation as far as they were concerned. So I don't think that was necessarily the case, no.
Judge Shaw.
Thank you for your evidence, Dr. Ellis. I just have a question. You stated in, I think it was, I'm very sorry. Thank you for your evidence, Dr. Ellis. I've a question about your paragraph 14 in your brief.
I'm sorry, I didn't catch that.
It's paragraph 14 in your brief.
Yep.
And this is the lawyer in me speaking, so I
Yes.
apologise. You say that where the birth father's family, especially the grandparents, wanted to adopt the child but had no standing. Could you tell me what you mean by the word standing?
Well, no grandparents had any standing legally. The decision to sign the consent was entirely the birth mother's. And in fact, it's one of the few occasions when, birth mothers as young as 12 could sign that consent
Yes.
without any oversight or anything. There was no requirement to consult anybody else in the family. And as I explained, even the father was not normally required to consent or be involved in the decision at all.
So when you say standing, you mean standing to give consent?
Well, no, standing to have any say
Or any
in the matter
say.
of the adoption, yes. And they certainly had no higher right to have the child, to adopt the child. In fact, the opposite, really.
Well, that's what I was going to ask. That was the next part. So they had no say in whether or not the child was to be adopted. What right, if any, do you think they had to be potential adoptive parents?
It seems that in the case of Maori parents, that they would often be put off by the social worker very early on, fobbed off. They would be told, no, that's not a good idea, and so on. But just on the grounds of how adopters, see, some adoptive applicants were turned down in general because they were too old or too poor or something like that. And Maori grandparents could very easily be judged on those grounds. So there were odd cases where the grandparents actually went to court to try to get the child and were turned down by the judge. So they were just, unless they had a Maori social worker who was facilitating this arrangement, they were very unlikely to be able to get the child. Either to adopt or whāngai or anything, they just were not going to get it.
So these Māori families were effectively disempowered from the whole process. Is that correct?
Yes, that would be correct.
Yes. Thank you for your question, for your answers. I'll pass you on to the next Commissioner.
Thank you. Ms. Lawhivai.
Thank you. Talofa Dr. Els, thank you very much for your evidence. When I was listening, there was something that was troubling me. I've heard some other narratives in some of the private sessions that I've had the privilege of listening to. And a recurring insight or a theme that's coming through is that kids who are put in foster care, and they're now like in their late teens, mid to late teens.
I'm sorry, I'm just having trouble.
Kids that were in their mid to late teens in foster care, there was pressure put on them by social workers to be adopted by their caregivers.
Oh.
Are you familiar with that? Yeah.
Yes. Well, the thing is that when children did not, for some reason, were not placed in adoption, or adoption broke down in some way, then they would end up in foster care while they were young. The hierarchy acted in foster care as well. Again, the better foster parents probably got the better babies, you know. And foster care parents did sometimes choose, want to adopt a child, and sometimes they were pressured to adopt a child. And how that went, just sometimes it was good. But I know personally of one case among my friends. Her mother had desperately tried to keep her in the hope that she would be able to marry the father, but she couldn't. And the child was placed with a fairly elderly foster couple from birth. And at about 18 months, she finally gave up and agreed that it could be adopted. And the foster couple who had had it from birth wanted to adopt it very much. But social welfare decided that it was, I might say, a Pākehā baby girl, decided that no, it should go to a better family, a clergyman, in fact, and his wife. So the baby was taken away from the foster parents, and I gather that this was quite an occasion, and police had to be called because they did not want to give up the child. And that child was her, and she had a relatively unhappy childhood and a relatively troubled life after that.
Thank you for that, Dr. Els.
Thank you. Mr. Gibson.
Thank you, Dr. Els, and thanks for bringing to our attention that various UN bodies have recommended an update of the Adoption Act. One specific aspect I'm aware of is that disabled mothers do not have to consent to have a child adopted.
That's correct. Well, no, it's not that. Their consent can be set aside. It is not required. The children of disabled parents can be adopted regardless, without requiring their consent. That was one of the points that Adoption Action, the group I belong to pushing for adoptive reform, brought before the Human Rights Tribunal, and they found in our favour that that was indeed a breach of the Human Rights Act and the Bill of Rights Act.
Are you aware of any of the stories of the birth mothers or the children in these circumstances?
No, I'm not aware of those. I haven't come across any cases in which that took place, no. I mean, I'm sure they did happen. I'm aware of cases where the mother was in an institution, for example, a mentally handicapped institution, and became pregnant with one of the other patients. And certainly in those cases, there was no consent involved whatsoever.
Okay, thank you.
Dr. Els, finally, myself, the Royal Commission has had evidence about people named social workers, people named child welfare officers, people known as Department of Social Welfare officers. We know know that post-1972, the Department of Social Welfare and its officers developed responsibility for this area. What I'm interested to ask you is the proper nomenclature, the proper name for those people responsible for adoption before 1972 and following the coming into force of the Adoption Act 1955.
They were always called we have to go back and remember that there was the department, the Child Welfare Division was a division of the Education Department. And the people who initially acted as social workers in regard to adoption were child welfare officers. And that remained the case up until the formation of the Department of Social Welfare. I just don't have the date to hand, but once that happened, they became social workers. And thereafter too, there was a little more attention paid to their training, because when they were child welfare officers, quite a number were really not trained at all. So the nomenclature changes in that way, and then of course it changes again. A special division was set up to deal with adoption within social welfare. And it was in the early 1970s that within that division they began to introduce or suggest at least the practice of the prospective adopters and the birth mothers meeting each other. And that took place around that time.
Thank you. Your answer clarifies an area that was certainly grey in my mind. May I join my colleagues in thanking you for your evidence and its clarity. And in addition, may I make reference to your book, which will be a valuable source of reference for the Royal Commission as it effects its consideration of this important subtopic. Thank you very much.